You are duly elected to be the acting chairperson for this meeting. Congratulations. You may proceed with the meeting then.
Thank you very much, Johan. I think I see the hand of Member Mari. Member Mari, before we continue.
Thank you. I seem to be having an issue with the raise hand function. I just wanted to second the nomination.
Okay. Thank you very much. And colleagues, good morning. And I have to hit the ground running with this one. I am going to introduce myself. As mentioned, my name is Matlodi Maseko, and I am with my colleagues that I'm going to ask them to introduce themselves. And colleagues, on the agenda today, we know we do have the briefing by the Department of Cooperative Governance on the Independent Municipal Demarcation Authority Bill, B14B of 2022. And we also we're going to receive the comments from the Department of Local Government on the same bill. So with that being said, I need to welcome each and everyone that have joined us. And I hope, Johan, if you can give guidance, our national colleagues, are they with us?
That's correct, Member Maseko. They are there. You can proceed with the introductions, then we may go over to the presentation.
Okay, so perfect then, and also the province are there. Just wanted to make sure that each and everyone that are expected to be in the meeting, they are with us today. And that being said, I'm going to ask that for connection, because we have a challenge of the load shedding. The videos, only if a person is talking with us can activate that video, but any other person, I will ask that we switch off our cameras to make sure that the connection is not disturbed one way or another. Honorable members, I'm going to call for an introduction for record purposes. If you can introduce yourselves.
Morning, Chair. Andrikus van der Westhuizen. I'm an alternate member standing in for the Honourable Seleku.
Good morning, Chair. Kayla Murray, member of the committee.
Thank you very much. Honourable Murray, if you can try and check the volume of because you too soft, it's a little bit difficult to hear you as you talk to us. Honorable Member Class, can you introduce yourself? I see you have joined us. Member Class? Okay, but I just saw him that he was joining us. I'm going to continue. For the apologies, I do have the apology of Member Seleku. Johan, any other apologies?
Chairperson, only from Minister Bradell. He can unfortunately not attend the meeting.
Okay. No, thank you very much. I'm going to request that our colleagues from National, if they can introduce themselves.
Good morning, Honourable Chair. I'm Kevin Naidu. I'm the Deputy DG at the Department of Cooperative Governance. I'm not sure if I should introduce my team or you would allow them to do that themselves.
I'm comfortable if you can introduce them. That will be appreciated, sir.
Thank you very much, Chair. So I'm joined by Mr. Wayne McComans. He's the Chief Director responsible for governance in the department. Mr. Sianda Nkeshli, responsible for governance and directly works with the Demarcation and Structures Acts. Mr. Nhlamulo Mate, also responsible for the legislation that I've just mentioned. But I'm also joined, Chair, by Ms. Lisa Naidu. She's from the Office of the Chief State Law Advisor, who's been supporting us on various matters relating to drafting, vetting, etc. of the bill that we have before us. That is the team chair, and leading us in the presentation will be Mr. Nkeshli. And as a team, we will then respond to questions, clarity, etc., that will be sought by the members in the committee. Thank you very much.
Thank you very much, Mr. Naidu. If I can hand over to the local government, if they can introduce themselves also, I'll appreciate that.
Thank you, Chair. My name is Kamal Makan, Director Municipal Governance, representing the Department of Local Government at this platform. I'm joined by Rudy Okes, who is within our Legislation Development Unit. And on the platform is also Acting Chief Director, Ms. Dr. Sandra Greiling. Thank you.
Thank you very much. Colleagues, I'm not going to talk about the rules of engagement. I think by now the virtual platform is our norm, and we know the do's and don'ts. Just to highlight, I see Johan.
My apologies, Chairperson. We also have members from SALGA on the platform.
Okay.
Sorry, I forgot to mention that to you.
Okay. No, it's okay. If they can introduce themselves, I'm sorry about that. I didn't know.
Hi, good morning, Chair Lady. My name is Paul Swart, the SALGA Working Group representing SALGA Western Cape.
Okay, thank you very much. Mr. Kutse, is Mr. Swartz the only rep from SALGA?
Chairperson, no, there are more of them. They can introduce themselves.
Okay.
Hello?
Hello.
Okay.
Candice, mute yourself, please.
What do you mean?
Candice, mute yourself. I cannot. Thank you. Oh, yes. Okay, I'm sorry about that. Can another colleagues from SALGA introduce themselves, please? Mr. Jansen?
Yes, Chair, good morning. My video has a little bit of challenges. My name is David Jansen. I'm responsible for Municipal Governance, SALGA Western Cape Senior Advisor. Thank you, Chair.
Thank you very much. Any other colleague from SALGA?
Morning, Chairperson. All protocol observed. I'm Loison Jamela. I'm responsible for IGR in the Western Cape office. Thanks very much.
Thank you very much. Any other?
Good morning, Chairman and members.
Okay.
My name is Armstrong Bella. I'm the Senior Advisor responsible for intergovernmental relations in the SALGA Western Cape. Thank you.
Thank you very much. You have been so wonderful to attach the name to the face, but okay.
Good morning, Chair. My name is Michael Chauke. I'm a specialist responsible for inclusive governance and councillor welfare from SALGA National Office.
Okay. Welcome. Okay, I think that's all. I'm not seeing anyone raising a hand. Colleagues, thank you very much. And my apologies, I didn't know SALGA has joined us today. And Johan, thanks for that. Like I was saying that we know the engagement is, you can raise your hand if there is any, you want to draw attention from the chairperson, which is from myself. So the interaction will be that way. Just the important info is we don't have any translation services today. So I would appreciate if we can communicate in English for all of us to be part of the meeting today, because we might have a challenge if we have to use any other language and not English. With that being said, I'm not going to waste any time. I know we are going to be led by by Dr. Kevin Naidu. who is going to lead us with the briefing of the bill that has been referred to the Western Cape Provincial Parliament. Dr. Karen Naidu, over to you, sir. And I know Mr. Wayne McCommons is also going to be teaming with you with a presentation.
Yes, thank you very much, Chair. I have more than just the two of us in the meeting, so I'm going to ask Mr. Sianda Nkeshli to lead us in the presentation. Okay. And then if you can allow us at the end of it to respond as a team, Honorable Chairperson. Thank you very much.
Thank you.
Sia.
Thank you very much. I'm not sure it's visible.
Yes, your presentation is visible to all of us.
Thank you very much. As well spelled out, I'm going to present the Independent Municipal Demarcation Authority Bill. As an outline, we'll just touch on the background, the structure of the bill. Then we'll just have an overview of clauses in the bill. But then I'll come up with a summary of the processes as well as amendment by the COCTA Portfolio Committee Chair. As part of the background, the amendments to the Demarcation Act are based on inputs from the present and previous boards, lessons learned from previous municipal boundary and what delimitation processes, litigation, and inputs from various stakeholders. The bill was published in the Government Gazette in June 2020 for public comments, and there were various engagements by DCOC, which included the workshop, which was convened in March 2017, where all stakeholders were there, and also the workshop convened in December 2020, where comments received from stakeholders were discussed with the stakeholders. Due to many proposed amendments, Chair, it necessitated that the Act be repealed and replaced with a new Act. As part of the roadmap, in March 2022, that was Cabinet approved that the bill be introduced to Parliament. Then in June 2022, the explanatory summary of the bill and prior notice of introduction of the bill was then published as required in terms of Rule 276. And the bill was introduced to National Assembly and referred to the COCTA Portfolio Committee in June as well on 21st. In March 2023, the COCTA Portfolio Committee published the bill for comments. That was closing date on 10 March 2023, but the committee felt that they should also have an extension to 15 June 2023. Then during July, August, and September 2023, the Portfolio Committee had public hearings, which were held in various areas around the country. October, November 2023, the COCTA Portfolio Committee considered the report on the public participation and it deliberated on the MDA bill. Then on the 30th of November 2023, National Assembly considered the report of the Portfolio Committee and approved that the bill be referred to the National Council of Provinces for consideration. Then now, as it stands, the bill has been referred to the National Council of Provinces. The structure of the bill, Chair, the overview. Chapter 1 deals with definitions and purpose of the Act. Chapter 2 is more about Independent Municipal Demarcation Authority. It is about the establishment, status, functions, etc. I'll deal with that when I go into details into each and every clauses of the bill. Chapter 3 deals with municipal boundary demarcation. Chapter 5 is much more about municipal capacity assessments. Then chapter 5 is more miscellaneous about the things that need to be considered when we deal with the bill. The overview of the clause of the bill, Chair, is as follows. I start like to say that the reason why now it is Independent Municipal Demarcation Authority Bill, it was just to align it with Section 155(3)(b) of the Constitution, which requires that a national legislation must establish criteria and procedures for the determination of municipal boundaries by independent authorities. So now that's why it's aligned with being Independent Municipal Demarcation Authority. Then in terms of the long title, we are saying that it provides for establishment of the MW, like I mentioned in the summary, criteria and procedures for the determination and the determination of municipal boundaries, delineating wards, capacity assessment of municipalities, establishment of appeals authority. That's a long title of what actually the bill is about. Starting with clause 1, it's about definitions, Chair, and it deals with various definitions of what is contained in the bill. Like you can see, the appeals authority, new authority, board, demarcation, etc., which I elaborate on when I proceed with the clauses. Clause 2 is about the purpose of the act, that the IMDA, establishment of the IMDA, which is Independent Municipal Demarcation Authority, set criteria and procedures for the determination or redetermination of municipal boundaries and delimitation of wards by the authority. Clause 3 deals with the establishment of the authority, which says the authority consists of members of the board and the administration. The aim of this provision is to differentiate between the board and the administration, which actually includes employees, Chair. Clause 4 is about the status of the authority, that it is a constitutional institution and independent and must be impartial when performing its functions. Clause 5 deals with the functions of the authority, which comes up to 4 major functions that the authority must do, which determine municipal boundaries, delimit wards for all municipalities that have wards, render an advisory service, and conduct municipal capacity assessment. Clause 6 is about the powers of the authority, that the authority is conferred with various powers to effectively perform its functions, and confirms that the authority may determine its own staff establishment and appoint employees in post on the staff establishment. Clause 7 deals with composition of the board. What is important is that now it removes the requirement of reflect regional diversity and provide that the composition of the board must broadly reflect the composition of South African society. And then clause 8 deals with the responsibilities of the board, that the board, the business and affairs of the authority must be managed by the board, and the board is responsible for the corporate governance of the authority and may exercise any other power and perform any other functions that the board is authorized to do in terms of the act or other legislation. Clause 9 is much more about the qualifications of the board members. It adds now that the board members must also be having qualification on information technology as additional qualification. And this is necessary, Chair, given that the work of the authority is generally technical in nature and utilizes ICT extensively. So it also addresses the issue of political office bearers, like full-time employees of an organ of the state cannot be board members. Clause 10 is about appointment of board members. So now the selection panel for the board members now will also include now the portfolio committee, representative in the National Assembly, and the Copter Portfolio Committee representative, as well as the representative of the National House of Traditional and Quezon Leaders. Clause 11 deals with determination and the term of office of the board members. So it states that it ends within 6 months after the commencement of the local government elections, which means 5 years and 6 months. On top of that, it will also ensure that a single board is responsible for the entire process of determining and redetermining municipal boundaries. So that's why now on top of 5, we've got that 6 months. A member of the board may not hold office for more than 2 consecutive terms. And it also states that if a board member is absent for 3 or more board meetings without being granted a leave of absence, then you see that member ceases to be the member of the board. Clause 12 is about conditions of appointment of board members. And then says that the conditions of appointment are finalized by the minister with the concurrence of the Minister of Finance. Clause 13 is about the chairperson and the deputy, where it says the president appoints one member of the board as a chairperson and another person as a deputy chairperson. Clause 14 deals about the meetings of the board, that the majority of the members of the board in office constitute a quorum. And then clause 15 deals with the rules. Board members must determine rules and procedures for conducting meetings. That's what is important. Clause 16 deals with committees. That says board will be required to establish at least the audit and risk governance committee and the remuneration and performance committee. And it says the criteria set out in clause 9.2 apply when members of the committee are appointed. That is, the name of the members of the board of the committees must be published on the website of the authority to ensure transparency. So just to recap to members, 9.2 deals with subsection 2 deals with that people must be solvent and then must not be insane and so on. So it applies also to those appointed to the committees of the board. Clause 17 deals with the delegation and instruction to exercise powers and perform functions by the board. So the board may delegate any of its powers to a member, employee, or a committee of the board, excluding the power to make the final decision on the determination of a municipal boundary. Clause 18 deals with the conduct of board members. So it requires that board members need to perform their functions of office in good faith without fear, favor, or prejudice, and must disclose all personal and or private business interest. Members who contravene these rules fails to comply with the above are guilty of misconduct. Clause 19 is about the chief executive of the board. So now the chief executive officer is the head of administration of authority for a period of not exceeding 5 years, but it's also renewable. So the CEO is accounting officer and must perform all functions and may be assigned to her or to him by the board. Clause 20 deals with the conditions of employment of employees. Board will determine the conditions of employment of employees which must comply with the principles of public administration as contained in the Public Administration Management Act. But also officials may be seconded from other organ of state to assist or serve within the board. Clause 21 is about contracting services, and that a person who is contracted to provide services may be remunerated and reimbursed for expenditure incurred while performing or providing those services. Clause 22 deals with the funding. The authority will continue to receive funding from Parliament and from any other source through the National Revenue Fund. Then moving to clause 23 is about determination or redetermination of municipal boundary objective, which says authority must determine boundaries in accordance with the objects of local government. And that should be aligned to also a SPLUMA. Then clause 24 is about factors to be taken into account. So the authority must consider now for the additional factors when it's determining municipal boundary. I think that is important, that it should consider common geostatistical building blocks which facilitate and support a standard geographical hierarchy, relevant national development policies and plans which might impact on the nature of local government and its boundaries, relevant policies and legislation relating to the institutional and functional reorganization of local government, natural endowments, resources, asset business investment, and other drivers of economic growth. And what is very important, the views of the people and communities living in the area. 25 is much more about determination of category of municipalities, which has been now moved from Section 2 of the Municipal Structures Act to the bill. 26 is much more about initiation and determination of redetermination of municipal boundary process. So the board will undertake determination or redetermination that affect more than one ward only after 10 years now. Priorities and time frames may be determined by only 3 years before the end of the municipal councils. But board will not determine or redetermine municipal boundaries after minister publishes formula determining the number of councillors. Clause 27, it requires the authority to publish a notice in the area concerned stating its intention to consider a request for the determination of a municipal boundary. So the notice will invite written representation and views from the public office within 30 days. Clause 28 is the board is required to institute a formal investigation unless if it is a minor technical adjustment after receiving views and representations from stakeholders. Clause 29 is more a public consultation for the determination or the determination of boundaries. So the authority has to publish a notice in the local newspaper informing stakeholders of public meeting. And the authority also to communicate the same message through other means of communication. Clause 30 states that the authority may establish appropriate mechanism, processes, and procedures as stipulated in Section 17 of the Systems Act to enable members of the public to participate in the demarcation process. Clause 31, it deals with the issue of publication of objection to a determination or a determination of municipal boundaries. So authority must publish its final determination in the Provincial Gazette for comments, and after considering any objections, the board must confirm or withdraw its determination by publishing its final decision in the Provincial Gazette. Board must also provide reasons for its decisions. Clause 32 stipulate that after finalizing a boundary determination, the authority must send particulars of determination to IEC and to relevant MSC for their views. Clause 33, it states that the authority must publish a delimitation of wards timetable in the Gazette after the minister publishes the formula for determining the number of councillors and may amend the timetable only on good cause shown. 34 is about the number of wards. So the number of wards in the metropolitan of local municipality must be equal to the number of wards councillors determined to the municipality in terms of Section 22, subsection 2 of the Structural Act. 35 is about the criteria for the delimitation of wards. Number of registered voters in each ward may not vary by more than 15% of the norm, where the norm is determined by dividing the total number of registered voters in a municipality by the number of wards in a municipality. But what's also important is that authority may deviate by not more than 30% of the norm in exceptional cases. Clause 36, it addresses the issue of public participation in delimitation of wards. So a similar process as clause 29 must be followed for ward delimitation as well for public consultation. Clause 37, Chair, is about publication and objection to delimitation of wards. Board members or board must provide reasons for decisions to those who submitted objections or to those who request such reasons. Then from clause 38 to clause 46, Chair, deals with the Demarcation Appeals Authority, which is just a very new in the demarcation process. So these clauses deal with the establishment of the Demarcation Appeals Authority. The current act does not provide for an appeal mechanisms or dispute resolution process against the decisions of the board, except for aggrieved persons to approach the courts to review the decisions of the board. So communities normally resort to violent protest where and aggrieved by the decisions of the board. So the DAA will allow stakeholders now to make representation to an independent authority if they are aggrieved by the decisions made by the board. Then what you see in the chair is just a summary of chapter 3, which I've alluded to. I'm not going to go through it. Then clause 47 is about municipal capacity assessments. So the authority has to conduct municipal capacity assessments to support its decision on the demarcation of the boundaries, and must also provide assistance and guidance to the minister and the MC regarding the assignment of functions and powers and render an advisory service. So authority must conduct at least one municipal capacity assessment in respect of each municipality during the term of municipal council for the respective municipality. Municipal capacity assessments must be completed at least 6 months before the end of the term of municipal council for handover to the incoming board. But the authority may undertake midterm assessment after 24 months and concluded within 6 months of the commencement of the term of a municipal council. Then 48 is about regulations and guidelines that the minister, after consultation with the board, may make regulations or issue guidelines on any matter that may be prescribed in terms of the Act. The minister must submit draft regulations to Parliament for parliamentary scrutiny at least 30 days before their promulgation. 49 is about offences and penalties. So now it empowers the board to summon a person with information that is needed to carry out his functions. And if that person refuses, such person may be liable for a fine or imprisonment. The present legislation chair does not provide for the board with this option of the sanction, which results in some instances in delays or failure to execute its functions. 50 is about amendment of laws. Chair, these are the laws and sections that are amended by this bill. And 51 is the transitional arrangements, which provides for ongoing and ending operations of the board. And then 52 is about the short title that the bill is called the Independent Municipal Demarcation Authority Bill. That is B22, 2022, and takes effect on a date determined by the President by proclamation in the Government Gazette. So the next slide, Chair, is just about the key features of the bill. We saw that we all know what it's dealing about. Mainly is that now the whole Demarcation Act is now repealed since 1998 completely, and that now we've got a new bill coming up now with IMDA, Independent Municipal Demarcation Authority, and then the authority is equal now to the board plus administration. That's what's key in this amendment. Term of the board is aligned with the term of municipal councils and also comes up with factors to be taken into consideration. Most of the views of the people and communities living in the area must be taken into consideration. It deals with that major determinations now must only be done after 10 years, and that no determinations will be done after the formula has been pronounced by the minister, formula for the determination number of councillors. It also now deals with the public consultation for determination or redetermination of municipal boundaries, investigation committee, etc. It also deals with the limitation of wards. That is mostly about may not deviate by more than 30%. It deals public participation and also deals with the demarcation authority, appeals authority, and deals also with municipal capacity assessments, which states that the minister may request authority to conduct assessments when authorizing municipalities to perform the Big Four functions. That is potable water, bulk supply of electricity, domestic water, sewage disposal systems, municipal health services. The next slide, Chair, is more about the amendments, which are already covered now in the bill, which were as a result of the portfolio committee input about what need to be also be considered in the bill. I'm not going to touch it completely, but you can see it is much more about broad to reflect in terms of the composition of the board. It must reflect South African society. It also deals about that board members must have relevant qualifications. And clause 16 deals with the criteria that the criteria set out in section and subsection 2 apply equally to the appointment of members of the committee. And the names of the members of the committee must be published on the website of the authority to ensure transparency. Then that one is technical to remove integrated development at clause 23, and clause 30, it deals with that the authority must establish mechanisms like I explained, processes and procedures as stipulated in the Systems Act. And then clause 32, it now says the authority must at least 9 months, before it was 6 months, prior to the commitment of the municipal financial year in which a determination or redetermination of municipal boundaries is to take effect, inform the minister and the Minister of Finance of such determination or redetermination. And clause 48 is more much to say the minister must now submit regulations to be made to Parliament for parliamentary scrutiny at least 30 days before their promulgation. Chair, I'm just recommending that the committee note the provisions contained in the Independent Municipal Demarcation Authority Bill. Thank you.
Thank you very much. Honorable members, that is the presentation. I am going to open for any clarity on the presentation from the members. I see Member Mare.
Thank you very much. Just two questions from my side. The first was, what essentially was the rationale behind the bill? So why are we looking at the demarcation now? Why is it important now? And then the second one was, what was the consultation that went behind drafting the bill before it got into its current phase, and whether there's any whether there'll be any further consultation before public participation kicks off? Thank you.
Thank you very much. Colleagues, I hope you note the questions. I'm going to take all the hands and then you will respond after members have asked the question as I see they've raised their hands. Member van der Westhuizen, I'm with you now.
Yes, thank you, Chair, and thank you for the presentation. I think we are still learning and we are refining a lot of our legislation, etc. And I see this as just one step in line with that. My question is, if I understood or heard you correctly, sir, you spoke about the board has got the right to revoke any decision by a committee or a staff member. Perhaps if you could just expand on that. I struggle to find that in the bill, but you know, perhaps if you could just draw my attention to that paragraph. But then also I'm concerned about the situation where somebody might be informed of a decision and then the board would like to change it. Apologies. And then the board would like to change it. And we have been struggling with a term recently called functus officio. You know, once somebody has made a decision, unless you also obviously inform the other affected parties that there is an appeal process, that decision is binding. So perhaps you could just help with that. And then secondly, Chair, I appreciate the fact that in certain circumstances, it's not possible to stay within the, can I call it, standard deviation of 15%, and that higher deviation between the sizes of wards may be required. And I appreciate the fact that this bill now does allow for that, but that it still be seen as exceptional cases which need to be motivated. So in that respect, I think this is just one example of where, as I've said, you know, we learn from applying existing practices and laws. Thank you, Chair.
Thank you very much. Member Atlas. Member Atlas, I see your hand is raised.
Yeah, thank you. Thank you.
Okay.
Are you hearing me now?
Loud and clear, sir.
Yeah. Thank you, Chair. I'm just apologizing for being late. I was trying my best to be in the meeting. And only my question is only number 20, where they talk about the condition of the employees. And then my question is that what is their follow-up or what is their role when the condition of the employees is not implemented. Because the way they explain is they are just telling us that what should happen, but they don't give that after it not been happen on when it had happened, what will happen for us to understand that this thing has been completely done for this condition of the employees. Thank you.
Thank you very much. I think this was a question, maybe one from me, because Member Mari covered me with the questions. The last one will be the cost that was attached to this bill, because usually we request that if we get the bill, can we also find out the cost of the bill as we take it that the bill is there to fix something, if there is something that has to be fixed. But we have to look at the cost attached to that. What was the cost? What is the cost attached to this bill from national? If it can be shared with us also, we'll appreciate the total amount to that. Over to you. Member Glass, I see your hand. Is it the legacy or you forgot to lower it? You have another question?
I forgot to lower it.
All right. Okay, I'm going to hand over. I don't know, you'll give direction, Dr. Naidu, who's going to respond?
Yes, thank you very much, Chair. And let me start with the responses to the issues that were raised. Let me just, as I begin, indicate to maybe Mr. McComans or to Ms. Naidu, if they can prepare to respond to the question from Honorable van der Westhuizen on functus officio and the decisions that are taken by the board. So the first question by Honorable Murray and the rationale for the legislation that we have before us. Let me start by saying, Honorable Chair, that the Demarcation Act number 27 of 1998 was the very first piece of legislation that had come out of the white paper process. So in its format at that point, there were many things that were not covered for in the Demarcation Act at the time. And therefore you saw different mandates of the Demarcation Board, not entirely in that piece of legislation. For example, the issue around capacity assessments. Capacity assessments are provided for in Chapter 5 of the Structures Act, and it is a key mandate of the board when it comes to drawing or determining outer boundaries of municipalities. It is a very important factor that must be considered. So with the IMDA bill that we have before us, one of the driving forces was that all of the provisions that reside in different pieces of legislation should be then migrated into the bill that we have before us. So it is not sections 84 and 85 of the Structures Act. It is not just Chapter 5 of the Structures Act that has been migrated, but we also have Schedule 1 provisions that deal with the delimitation of wards that have been imported into the bill that we have before us. In addition to that, we also have provisions from the Systems Act dealing with capacity assessments that we have now taken from that piece of legislation into the bill. The second major thing is that when you look at the provisions or the sequencing of some of the provisions in the Demarcation Act that we have presently, when you look at Section 21, for example, it deals with the board publishing the final determination that it has made. And then when you look at Section 26 of the Act, it deals with public notification of boundaries. So consultation in Section 26, and then finalization or final determination of the board in section 21. So for us, the sequencing in some of those provisions were not correct. You would see governance issues in the demarcation bill towards the end of the Demarcation Act as we have it now. And in the bill that we have before us, you would see that the sequencing of governance issues are kept upfront in the Act or in the bill, and other real core business of the board then following therefrom. Around consultation on the bill, so you would have noticed from the initial slides that Mr. Nkeshli had made that the genesis of the bill has its roots going back to 2007, but immediately after the first board had ended its term, so it would have been in 1999, in 2004 and thereabouts, lessons that were learned from the very first redetermination process that had commenced in 1999 and which had come to an end after the first term, informed the proposals that were made to the department by the board at the time. So that was what initiated discussion or a call for amendments to the legislation. And of course, various determinations that had taken place thereafter informed what we have in the bill presently. For example, you will notice that we have now provided for major redeterminations, and a major redetermination is defined in the bill as moving more than one ward wholly from a municipality to another. And we're saying in those instances, it would happen after 10 years. So we're trying to ensure that we have some form of stability and not changes to boundaries from time to time or every term that we would have the board undertaking this redeterminations. At a government level, we've had various workshops on the bill. Referenced in the presentation is 2007, where majority of government departments were invited to a two-day workshop where we dealt with the Demarcation Act, the bill, as well as the Structures Act amendments, and then which you would recall came to fruition in 2021 when the Structures Amendment Bill was passed through Parliament. So the consultations, further engagements had taken place with stakeholders post the publication of the bill in 2020 for public comments, and then post that consultation process or the invitation for comments, we had invited the stakeholders again to a further workshop where all of the comments that we had received were considered, which informed the development of the bill. And as you would know, the processing of legislation is done through various committees. Comments that would be made there are further considered, incorporated into the bill, and of course, before it would come to Parliament, it would need to be processed by the State Law Advisor before we can get approval to submit to Parliament. Honourable van der Westhuizen, ma'am, deals with or raises the issue of the revoking of the decision by the board. And when you look at clause 17 of the bill, it is where it is provided for, and it says that the board may confirm, vary, or revoke any decision taken by a member of the board, committee of the board, in consequence of a delegation or instruction to exercise powers and functions of the board. So it is a board as a collective that has that responsibility. The matter raised, or the second matter around functions of FICU, Honourable Chair, I've requested the colleagues to respond.
Thanks, TDG, and good morning to the chairperson and honourable members and my fellow colleagues. Yeah, I think you're correct, TDG, is in relation to clause 17. And it's probably something we will have to probably consult on, because my understanding is that their provision is applicable when there's no specific power provided in legislation for a particular functionary to revoke his or her decision. In this instance, we have made provision for that specific power for the board. And I guess we will have to assess the application of that particular doctrine within the context of the fact that we've now made specific provision in the legislation for the board to revoke its decision. But let me maybe, I don't know whether Lisa wants to add to that, but my guidance will be, thanks for the comment, honourable member. I think we will have to engage on that on the side with our legal guys to see whether that doctrine is in fact applicable, noting that we have made specific provision now for the board to revoke a decision they've made. Thanks, Chair. Thanks, DG.
Okay, you want to add, Lisa?
Thank you. Good morning, colleagues and honorable members. I was actually thinking this related to the appeals process, because when it comes to the appeals process and querying any decision or objecting to any decision, it's done within a specific time frame of the 30 days after the decision. But now the colleagues have drawn my attention to section 17, or rather clause 17.3. The board may confirm, vary, or revoke any decision taken by a member of the board, committee of the board, or employee in consequence of a delegation or instruction. When it comes to this legislation, it will be from the date this legislation becomes operational, that board, that section will apply to that board. And when it refers to decisions that have been taken by previous boards, if it's been executed, that is all well and good. But the board that comes into operation or is existing at the time that this legislation is coming into operation will follow whatever decisions were taken by the outgoing board by the principle of successor in title, unless it can be proved that that decision is no longer applicable because it's obsolete, it's no longer, circumstances change in that regard, or on the basis that it's so grossly irregular, or the current board now determines, let's make a ruling that we no longer want to follow that. I hope I've given some clarity with respect to that.
Thank you very much, Lisa. If not, I think the honourable member will come back after we conclude with responses. The other matter raised by Honourable van der West is related to the 15% and then the 30% in exceptional circumstances. So this is a new provision that has been included in the bill. And it is informed by instances where in the past we've had split communities. Split communities because the norm was too constraining in its present format. So for example, if you have a norm of, let's say, 1,000, so a norm is the number of councillors or the number of registered voters in a municipality divided by the number of councillors, which would give you a number, and that number is referred to as the norm. So let's say, for example, in Laingsburg, where the norm is 1,000 for a ward, it means that if the norm is 15%, it means that the number of registered voters in a ward when compared to another ward in that same municipality may not be less than 850 or not more than 1,150. The problem would be where if you use the 850 as the bottom end, or 1,150 as the upper end. And if you had reached the maximum of 1,150, and there were another 200 registered voters in the neighboring ward of the same community, if you had stuck to the 15%, you would not be able to incorporate those 200 persons into this ward, and therefore you would result in a split community living in two wards. But if the ward norm was 30%, then that would have been 1,300, and then you would have been able to accommodate those extra people into the neighboring ward. So that is essentially the rationale for having the norm moved from 15% to 30%. And you would see in the bill, it is instances where you would want to have that to avoid the fragmentation of a continuous built-up area, where the voting station falls outside of the ward, and also in instances where you would want to align to an identifiable topographical and physical area. But it does not end there. Where you would want to apply the 30%, you would need to ensure that that proposal is published in the Government Gazette for comments before the matter can be finalized. The matter raised by Honorable Klaas related to conditions of employment. And what we've done here is to have aligned the provisions in the bill to provisions that reside in other new generation legislation, if I can call it that. And the legislation that comes to mind is the Water Management Authority Act, where reference is made to the Public Administration Management Act and not to other previous legislation that we had. So that is essentially what Section 20 deals with. Of course, the Demarcation Authority is an employee in its own right. It is a Schedule 1 entity, a constitutional entity, and of course, all other legislation applicable to institutions of that nature in relation to employment, conditions of employment, etc., would be applicable. The last question by Honorable Maseko, our chairperson, in relation to the cost of the bill. Ma'am, I'm not sure what exactly relates to cost, but I can say this, that the bill has been drafted in-house by our own legal drafting unit in the department. It has been vetted by the state law advisor. The socio-economic impact assessment study that is normally required by government, which is required in terms of processing any legislation, was also done in-house. So internal resources used for that. Perhaps for the convening of engagements by the department, there would have been a cost associated with that. But that is as far as costs incurred by the department related to the development of the bill. Honourable Chair, I think those were the questions, issues that were raised. If there's any other matters, we are willing to respond to same. Thank you very much.
Thank you very much. I think okay. My question is, it was more of the cost implications, because I saw on one of the clauses that the payment for the board and all the appointments, the National Revenue Fund will be cover the cost, but the bill also have to, in a way, I'm asking it will have a business plan of the cost that will attach to that my layman language of the thumb sucking of the cost attached to all that, it will be how much you're looking at. And I was talking because it's based on the budget cuts that is happening throughout in this country, and the cost implication of it, will it shortchange any other thing or not? So I'm trying to align that anything that we introduce as the members of the parliament, the cost implication to treasury, to what an extent will it be impacting negatively or positively? So from where I am now, it's more negatively. If there's anything else that will have to add to the cost implication to say there is more money needed. So I wanted to find out if that has been thought in advance to say that what will be the cost implication that will be to the country if we have to go on with this. And that is what I was saying, is aligned to the question of Member Maria about what are we fixing with this bill, or what is not working, and with this, what is it that will be improved? I see the hand of Member Maria and Member Van der Westhuizen. In that order, members.
Thank you, Chair. Chair, I just 2 questions from my side. I think if I was to go to an ordinary member of the public and to explain the purpose of the bill in the most simple language possible, how exactly would you package that? Just so there's a lot of jargon, and it's difficult to sort of translate that from a legislative perspective into what will practically happen to each ward in the metro, or each ward in the various districts. And then also just an understanding of essentially when that will take place, or how long do we foresee this process unfolding? Thank you.
Thank you very much. Member Van der Westhuizen.
Yes, thank you, Chair. Chair, I want to just refer to paragraph, let me just see that there, I think it's 11(1)(a). It deals with the term of office of board members, and I'm grateful that we have representatives of SALGA here as well. It currently reads as follows: and such term may not exceed a period of 6 months after the commencement of the term of the next municipal council. Now, I presume the reference here is to the various municipal councils at local government level that we have in South Africa. And what we also do know is that the term of office of councils do vary. For example, your so-called district municipalities, their term can only start, and they can only have their first meeting once all the municipalities in that district have had their first meetings, and what is more, after they have decided on the delegates to the district council. So we quite often find that district municipal councils only meet for the first time 2-3 weeks after the elections. And if I may humbly propose that perhaps the drafters should look rather at the date of the local government elections at the national level than use the term of the next municipal council, because obviously there are numerous municipal councils. What is more, we do find that under certain circumstances, certain municipal councils may be dissolved, and that they will then have an election in that demarcated area, and that a new municipal council may be formed. Can I call it midterm, or at a date that does not coincide with the dates of the national local government elections, which come around every 5 years? So perhaps if I may ask that the drafters just look at 11(1)(a) and perhaps rather link it to the national election date for local governments than to refer to the commencement of the term of the next municipal council, unless I have it completely wrong. Thank you, Chair.
Thank you very much. What can I do? Member
Thank you.
Andrikas, I'm sorry, Dr. Naidu. Member
Yeah.
Andrikas? Oh, okay. I thought that maybe you forgot another question.
No, thank you. It does take a while sometimes for the hand to be lowered. Thank you.
Okay. Yeah, the Teams today is playing balls with us. Over to you, Dr. Naidu.
Thank you very much, Chair. I did see my colleague, Mr. Nkeshli, having his hand up. Maybe if I can, through you, Chair, invite him to make his input, and then I will respond to the issues that were raised by the two members.
Okay, that is in order, sir.
Thank you. Sia?
Thank you very much, Chair. I think the question by the Honourable Member Murray was about how to simply translate to the member of the public what the bill is about. I could pick up three main things, Chair, on this. That one, the bill seeks to improve on the demarcation processes. Secondly, the bill is now explicit on public participation when the board is conducting its business of determining the boundaries or during actually the delimitation of wards. And thirdly, it provides for the appeals authority, demarcation appeals authority, which is now a body that allows a dissatisfied member by the decision of the board to appeal if that member is not happy about the decision of the board, which didn't exist before. That's the response to Honorable Murray. And then the next question was about the term of office of board members, and by Honorable Van Westhuizen, and then was saying that now it will now cause a problem, need to be looked at the drafting. I think, Honorable Member, the Structures Act is amended. Act number 2 of 2021 addressed the issue of when the council is declared elected. And declared elected now in terms of the definitions in the Amendment Structures Act is that is on the day when the IEC pronounced the results of the election. So all councils, once the IEC pronounced the election results, then all those councils have been declared elected. So it doesn't create any vacuum now as to when the council exists. So that's where this 6 months will commence. Thank you very much.
I can maybe just add, Honorable Chair. So the matter that you raised around cost. So presently, the way the demarcation board receives their funding is from the revenue fund through the department. And you're right in that we across government find ourselves where the funding that has been allocated has been, there's been implications for all institutions as far as I can recall, including the demarcation board. So of course, one would need to see how reprioritization, et cetera, would take place in order for the board to ensure continued processing of issues, functions, responsibilities that they must do. How would you package it? And I think Mr. Nkeshli tried to respond to it. So key for us in the bill is that we've put communities and the citizenry at the center of it. And I think if at a high level, if the committee is planning on undertaking a consultation process with communities to, at a high level, indicate what outer boundaries and inner boundaries determination and delimitation is, but also to unpack the step-by-step processes that we find ourselves in sections, either chapter 3 of the bill, from sections 23 to 37, that talks about what happens in both these instances of outer boundaries and inner boundaries and the involvement of communities in that regard. I think an important matter or provision that should be brought to the attention of our communities is the intervention or the proposal around the establishment of the Demarcation Appeals Authority. So this also, has been something that has come from the ground up, where the only recourse in terms of the legislation that we have presently. So when a person is aggrieved by boundary and ward delimitation, the only recourse was through the courts. And we're saying, okay, here is now the Demarcation Appeals Authority, providing access to those communities that do not have the resources to go to court in the establishment of the Demarcation Appeals Authority. So for me, those would be some of the things that you would want to see how is shared with during your stakeholder consultation processes. In terms of the 6 months that was raised by Honorable van der Westhuizen, and I just want to add to what Mr. Nkeshli had said. So presently we have a scenario where boards, you have different boards that are responsible for different responsibilities by virtue of their tenure. So the 5-year tenure finds boards being responsible for outer boundary determination, and by the time the term comes to an end, they would need to hand over to another board to do ward delimitation. So case in point, so if you look at where we are presently, the present board term comes to an end at the end of this month. They have just concluded outer boundary determinations, and a new board would need to be appointed from the 1st of March, which is next month. And that incoming board would be responsible for inner boundary delimitation. So the way the bill has now been drafted is that a single board will be responsible for both outer boundary determination as well as inner boundary delimitation. So a single board responsible for both those responsibilities, and of course, now being aligned to the term of municipal councils, and the definition of when that term starts or ends is provided for in the legislation that was introduced in 2021. Honorable Chair, that was the question that was raised in the last round. Thank you.
Thank you very much, Dr. Naidu. Members, I don't see any hand now. Without a hand, I'm going to ask if there's any questions from the SALGA before I hand over to the Department of Local Government, the Provincial Department of Local Government, a briefing that will be made by Mr. Kamal Makan, the Director. Member, Honorable Station. I see your hand.
Yes. Thank you, Chair. Yeah, I find this issue of the term of the board a very interesting one. The commencement of the term of the next municipal council obviously leads us to the legislation in terms of municipal councils. And interestingly enough, I see Act 3 of 2021, that amendment said an elected council is deemed to assume office on the date of the declaration of the results of an election by the Electoral Commission. That is the office date, or the date on which office is assumed. But we also do know that district councils, must be, well, every council must determine its representatives to the district council within 14 days from election and I'm referring to section 23(4), where it says a local council must appoint its representatives to the district council within 14 days after the result of the election of the local council has been declared. Now, the 5-year term is a very interesting one. I find it very interesting because it says 6 months, such term may not exceed a period of 6 months after the commencement of the term of the next municipal council. Now again, I think it should be worded in the plural then, because we have numerous municipal councils. But then also, what we do know is that councils, the term of councils, are determined or by law as a 5-year term from the date that the IEC has declared the previous election. So what we now have is that let's say the board will be formed today, and let's say that the elections in 2021 was on the 1st of November, then that term will now run for 6 months after the 1st of November 2026. And yeah, I find the wording very, very interesting there, in the sense that the term may not exceed 6 months after the commencement of the term of the next municipal council. So that date will actually be determined by the previous election date. And what we do know is that term of the next municipal council can actually deviate by 90 days, just as in the case of the national election, which 5 years ago was, I think, on the 8th of May. That date can now be brought forward or moved outwards by 90 days. So I just find this a very interesting definition or stipulation that that even if the next municipal council's term would be lengthened by 2 months or 3 months, that it would still be the 2021 date that will be determining the final date of the demarcation board. And I think it could have been dealt with perhaps a little bit differently. Thank you, Chair.
Thank you very much. That is why we trust you, honorable member, to submit when we formulate our negotiating mandate. That is one of the things that we'll have to put in there. Maybe it will be taken from the NCOP. I saw our SALGA rep.
Thank you.
Over to you, sir.
Thank you, Chair Lady. I've listened very carefully, and also very important what you've just your inputs was, what will bring this, what will bring it differently to the surface? What will improve? For me, it's very important. We're building on the greater puzzle, public participation, the sustainability of the municipalities, the empowerment of people on the ground level. Chair, I'll ask Mr. Michael Chauke to give inputs from SALGA, if Mr. Chauke is still on this platform. Mr. Chauke?
I am still here.
Okay. I thought maybe it's a question. Let's work it this way. I just wanted the Department of Local Government, and then after it will be the SALGA. And then we, in that order, it will work for us if we do it that way. We just want to get, if it's okay with you, I'll appreciate you that we do it in that fashion.
Sure.
Okay, thank you very much. Mr. Is there any maybe comment with what member Panel Vestesen have said, Dr. Naidu, that you want to make before I hand over to Mr. Makan?
Honorable Chair, I think you have made a very good proposal on how we could look at it deeper and perhaps coming through your negotiating mandates that will be submitted.
Okay.
Thank you very much, Honorable Chair.
Okay, thank you very much. Mr. Makan?
Thank you, Chair. I'm just going to flight my presentation.
Okay.
If you let me know that if whether it's visible, thank you. Chair, I'm not too sure if it's visible.
Yes, it is.
Thank you, Chair. Chair, just at the outset, I need to indicate that the bill that is currently before the committee, we've submitted comprehensive comments on the bill, but a previous version of the bill, and just need to commend my COCTA colleagues because they've incorporated much of the comments that we've given previously into the current version. So we just have brief comments based on those that have not been incorporated in the current version, and then also based on a further analysis of the version of the bill that is before you as well. Chair, just with regard to Chapter 1, we picked up and we're talking about the definitions under Clause 1. The definition of president, there are various cross-references to the term president. I think for an ordinary layperson, we all know what we're talking about, but at the end of the day, for the sake of completeness, and we're talking about national legislation here, there should be a definition provided for the president. And we're suggesting that as contemplated in Section 83A of the Constitution, and that we would recommend that a definition be inserted for the president, which is transversely mentioned throughout the entire bill. I won't go through the clauses. The clauses are indicated there as well. Chair, thank you. Chair, just on our comments regarding the composition of the board, and in particular clause 7.2, the clause makes reference to the composition of the board being broadly reflective of the composition of South African society and collectively representing a pool of knowledge in issues relating to demarcation. But however, we've indicated this previously in our comments as well. There should be more emphasis placed on gender, and the bill should clearly require that there must be a fair composition of board members in terms of gender. In relation to clause 11.4, Chair, we've picked up that clause 11.4, if one reads it, it provides, and if I can get the opportunity of just reading it out, it states that members of the board are appointed on a part-time basis, except for the chairperson, whose appointment may either be full-time or part-time. Now, by virtue of clause 13.1 of the bill, the chairperson is a member of the board, and therefore, in terms of the former part of clause 11.4, he or she will be part-time by virtue of clause 13.1. Hence, there's no need to repeat that the chairperson may be part-time. I think the language construction of the clause 11.4 should be revised for the sake of redundancy. Chair, pertaining to clause 19.3 B, the clause makes reference to seconded. There are various other provisions in the bill which also makes reference to seconded. I think it's viable and justifiable to state that there should be a reference to the legal authorization of such secondment. Example, the Public Administration Management Act, Section 6, makes and provides for such secondments. But I think for purposes of loosely using the term seconded without making a cross-reference to Palmer is obviously will create uncertainty and confusion as well amongst readers of the bill or the implementers of the bill. So we're suggesting that there should be a definition in clause 1 defining seconded or secondment, which may be have the corresponding or same meaning. Chair, pertaining to clause 24, the factors that are set out in clause 24 are supported, and we just indicate that there needs to be more careful identification and elaboration. In this context, and this is in the context of clause 24, for example, there should be a further factor that could be incorporated and which is integral when one is dealing with redeterminations, bulk service provisions, particularly water catchment and service areas, which includes waste management. These are integral factors that should be taken into account as well when one is conducting a redetermination. Pertaining to clause 25.3, Chair, and this pertaining to a category A municipality, the term to describe the factors in determining the establishment of a single category A municipality are too broad in our view. For example, if you look at the clause 25.3a, it makes reference to a conurbation featuring an intense movement of goods. So this raises the question as to how does one quantify this?
Sorry, Chair. Could I ask that Kamal please put his presentation in slide mode? It's quite straining on the eye, Kamal. Sorry, Chair.
Yeah.
Is that okay?
Yeah, that's far much better. I'm blessed because I've got the spectacles, so I was not complaining.
My apologies, Chair.
Okay.
So in relation to, if I can just maybe repeat what I said, with regard to clause 25.3, you know, I think the fact is there should be factors that should be quantifiable. And we've given an example there. If one looks at the term an intense movement of goods, you start raising question as to how does one quantify that? We've also recommended that there should be a use of quantified factors, such as that contained in the South African Functional Town Topology work undertaken by the Council for Scientific and Industrial Research. That will give guidance as to factors that one should be taking into account, especially with regard to determining a municipality as a category A municipality. For example, I mean, there are various factors that are contained in the study by the CSIR, which may be brought into section 25.3, Chair. Chair, just with regard to clause 26.1, we've picked up and we've commented on this previously. However, it hasn't been changed or amended or revised. And that's pertaining to the clause providing that the board may only determine or redetermine a municipal boundary regarding the categorization, amalgamation, or any boundary change which affect the movement of more than one whole ward in a municipality every 10 years. Although this proviso attached to the time frame is associated with the movement of more than one whole ward. So in other words, if it's only if there is a movement of more than one ward, that can only be conducted every 10 years. This is what the provision is providing. However, it's unclear as to how the drafters have come to the period of 10 years. There should be a reasoning as to, or underlying basis as to why a 10-year period was chosen. Furthermore, if the factors listed in clause 24 have been considered and points to the need to undertake such demarcations, it is unclear why the board must wait 10 years to do so. The time frame raises questions, especially in the context of the fact that many municipalities are experiencing challenges at the moment. I don't want to specifically refer to municipalities where there's poor and no service delivery to the local communities. And a 10-year period in this context to determine or redetermine a municipal boundary, especially with regard to an amalgamation, is extremely long. Chair, further clause that we just wanted to provide a comment on, and which we picked up, is clause 29.8. At the public consultative meeting, there should be a provision of a translator to address the vernacular needs of the public in the region. This is a need identified, which we have identified in past when we've supported and assisted the MDB at the public consultation processes. A lot of the public members that were in or were in the audience are not even English speaking. So, you know, there needs to be a consideration of that in that particular clause, Chair. Chair, just pertaining to clause 36.1, it provides for the delimitation of wards and the public consultations again, but now contained and pertaining to delimitation of wards. I think there needs to be an express provision in the bill currently with regard to the costs associated with such public consultations. In the past, again, and we're coming from a practical point of view, we've had issues with municipalities who did not, want to bear the cost, especially with translation services, audiovisual equipment. So there should be a provision that indicates that the MDB will cover those costs. Sure. With regard to 51.1 and 3, we've picked up, if one looks at the transitional arrangements, unless the State Law Advisor's Office can maybe clarify that provision. If one reads clause 51.1 and 3, it still makes reference to the Municipal Demarcation Act. However, this now can't be, it would be futile to make reference to the Municipal Demarcation Act, whereas the purpose of the current bill is to repeal the Demarcation Act. So our view is that, there should be a review or a relook at the contents under Section 51, especially with regard to transitional arrangements, because those are important, especially with regard to decisions that are currently being made by the MDB. And then we've got the bill coming and being promulgated as an act. One needs to have a relook at the provisions there in order to protect and enforce the actions that are taken by the current board as well. Chair, thank you. That's for from the Western Cape and the Department of Local Government. Thank you.
Thank you very much. I'm going to take Saga before I take any clarity from the members. Can get a briefing from Saga. Mr. Chauke?
Thank you, Chair. I'll share just shortly.
Okay.
I hope it's visible.
Let's wait a second. There we go. Okay. If you can also do the same for those that don't speak, say it's not kind to them.
Sorry,
just to put it on a slide mode.
So from my side, it's on slide mode. Is it on slide mode now?
Okay, I think they can. There we go. Perfect.
Okay.
You can continue, sir.
Thank you very much, Chair and members. We reflect on the comments on
Okay, Mr. Chok, I don't know if it's me, but we are losing you a bit there. Members, is it me or from your side also?
Yes, on our side it's the same.
Is it better now?
Mr. Chok, just say, just read to present comments. Let's hear if you'll finish it until the authority bill, that first sentence. Mr. Chauke? Okay, I don't know. Mr. Swartz, is there anyone who can take over, because it seems Mr. Chauke, we lost him a bit. That's a
Okay, thank you.
synopsis.
Armstrong, are you ready? Maybe you can take us through, Armstrong.
Sorry, Chair, can you hear me?
Okay, there you go. We can hear you now. Don't move.
Sorry.
Just stay there.
Sorry about that. I'll just replace the.
We've got you. We lost your presentation.
Yeah, I've really put it. I hope you can see it.
Yes, we can see it now. You can continue, sir.
We present the comments on the IMDA bill, as well as we reflect on on a study that SALGA did around 2018 on the impacts of demarcations on municipalities, particularly
Hello, members, we lost
hear
Mr. Yeah, Mr. Chauke is gone again. We'll have to get someone, Mr. Swart, that is stable with connection. Member van der Westhuizen said, can you hear me?
Indeed, loud and clear, but you're the only one that is audible at the moment.
I can hear you as well.
Okay, Helen's still there. Dr. Naidu, are you audible?
Yes, I can hear you clear, Honorable Chair.
So it's only the Mr. Chauke.
And I'm in Pretoria.
Okay, that's a good one. Mr. Swart?
Chairperson, I think I'm trying to get Armstrong. If he can maybe take us through.
Yeah.
Or Chauke just try to word is Chauke back on the platform now?
Yes,
yeah,
I am.
I just admitted
Mr. Chauke,
Mr.
can you try
Chauke.
again for the last time, maybe?
Sorry about this, honorable members. I hope it's visible now.
Yeah, it's visible.
In terms of clause 8, which talks about responsibilities of the board is responsible for the cooperative governance of the authority, including, and we make the comment there, looking at the state of some of the SOEs, particularly around the governance challenges, especially related to the fiduciary duties of the board. We should not underscore this, and we propose for additional inputs in the form of the board should act independently at all times with unfettered discretion, exercise independent judgment, and take decisions according to the best interest of the institution. So we just want a strengthening of that particular clause to ensure that the fiduciary duties of and responsibilities of the members of the board is strengthened in that regard for effective good governance. And in terms of clause 16, which talks about committees, when appointing members to the committee, the board is not restricted to members of the board, but at least one member of the committee must be a board member. This talks to the subcommittees of the board. So in essence, what we want, with no limitation provided for upfront for the co-option of members, does not be open to creating a board within a board. So we fear that if you're going to create subcommittees and it only requires only one member of a board, it could lead to a situation where members who were not eligible to become board members or did not meet the criteria there too could be co-opted into the board, and this could create a board within a board. So we should have a limitation on the number of board members that can be co-opted. And also further on, in terms of that, it may authorize a committee to co-opt advisory members within limits determined by the board. The criteria and qualification for the co-opted members are not specified. So the bill specifies the requirements for the members of the board, but there is no requirement linking the co-option of additional members. And this should also be in line with the requirements for the composition of the board, so that the criterion that establishes the establishment of the board members should be the same for the co-opted members, so that it's not outside of that. And we also recommend that in terms of the rationalization of municipalities, it should also be taken into account based on the studies that we've done previously, one of the issues has risen out of the major redemarcations that have been undertaken since 2000. Section 41 of the Municipal Demarcation Act makes provision for the minister to make regulations which prescribe objectives and general targets for the rationalization of municipalities as contemplated in Section 25I. This rationalization policy should take into account socio-economic and development needs of municipalities, as well as how to address cases where provincial boundaries affect municipal boundaries. We do take cognizance that the board is not necessarily seized with provincial boundaries, but this has an impact on municipalities, and this should also be factored into the thinking of the board when they do redetermine municipal boundaries. And also issues around governance that then do come to the play. A formula to determine councillors while distinguishing between categories of municipalities and other overall budgets, population, and the like does result in situations where contiguous municipalities may have very different arrangement in terms of the numbers of councillors relative to voters. So what may happen is that you've got a big municipality merging with a small municipality, and there's an over-representation of councillors from the bigger municipality in the new amalgamated municipality, and some of these also need to be taken into account. And it also has a likelihood of moving these councillors from the lower graded municipality to a higher graded municipality. It's got cost impacts on the new established municipality. And what we've seen in the past, which I'll address shortly, there's not been sufficient allocation in terms of the transitional grant. It only provides for a 1-year transitional grant, and what we're calling for, it must be over the MTF period. And I'll explain why in a moment. And also around issues of sustainability of municipalities, it is clear from the study that the merged municipalities have often been the result of one or more municipalities having poor and limited economic basis compared with the neighboring municipalities. And in the past, it's even been proposals to merge municipalities based on them not being financially viable. So what it proposed in that instance is to take two municipalities who are struggling financially and amalgamating them to create one new municipality. And I don't think that's an answer to the challenges that are pervasive in the sector around the sustainability of municipalities, and we need to look at it in a different light. And once again, a reflection on the distorted apartheid spatial patterns, demarcations often becomes a means through which the limited economic basis of merging municipalities can be combined with the intention of reducing fixed costs of municipalities into a single management structure, merging economic basis. We believe that during the demarcation process, the MDB should conduct feasibility studies, investigations in all cases to better inform the implications of determining boundaries, or taking into account also the financial situation of those municipalities, because in some of the previous amalgamations and mergers that we've seen, it has resulted in municipalities that were performing well being merged with struggling municipalities, and they continue to face those hardships even to this day. So it creates further challenges within the overall sector. And furthermore, there's some evidence, while mergers may not have been responsible for improving the stability of senior management in local governance. Where there is existing stability among senior management, the mergers appear to perform better. So in part of the change management processes, we need to ensure that senior managers are appointed at an early stage who are competent, experienced, and have got the requisite expertise to be able to discharge their responsibilities to be appointed, so that they bring about stability in that municipality, so that there is stability from that front. And what I referred to earlier on around transitional funding, mergers can have a significant effect on political stability, leadership, and governance and service delivery systems. In the case of mergers between category B and A municipalities, whilst the category A municipality does have the capacity to manage such mergers, it is usually faced with significant short-term costs in the amalgamation process. And we've seen this previously with Tshwane and Msweding, and also what the challenges we are seeing now in Mangaung based on the previous amalgamations. It is recommended, therefore, that 3-year budgets are provided by National Treasury for such mergers, which should allow such transition costs, human, financial, technical, to be accommodated. So before the demarcation, the authority will then consider, they must have engagements with the relevant stakeholders, including Treasury, to see whether there is a budget that will be set aside for a 3-year budget, so that you do not set up a municipality to fail from the very onset of the life of that municipality. And National Treasury should continue to monitor and, where needed, support such municipalities beyond the 3-year transition period. The funding should not just be limited to the integration of administrative systems, but should also allow, for example, for funds to assist municipalities becoming sustainable, because it comes with a lot of resources that are required in terms of the transitional period. You have to have a new organizational structure. You have to relocate people from one center to another center. You have to rationalize bylaws, municipal policies, and so forth. So there is a significant cost that comes with transition of municipalities, and we need to ensure that in the demarcation process, the authority does consider this and also is factored in terms of the planning of the National Treasury. And we also make comments around redetermination of municipal boundaries and delimitations. Ward delimitation process is highly emotive and involves many stakeholders for consultation and for proper planning. In line with the municipal boundary determination, the ward delimitation should be done after 10 years. So there is a standing provision that the outer boundary process will be done after 10 years. We also propose that for the inner boundaries, this too should also be after 10 years, so that we lessen some of the constant changes that are always happening. And in terms of the illogical ward boundaries cutting across houses don't respect landscapes or any area in question. And I think some of this is starting to be factored in terms of revising the norm. So what we've seen in some instances, communities have been split, and this has caused a lot of the problems. You find even in traditional areas, communities belonging to one traditional leader have been separated into different wards, and we need to look into those. What we also call for in terms of the administration of the authority, the lack of provincial offices to bring the authority closer to the provinces. Provincial representation offices is proposed as opposed to centralized national office. This should make it easier for municipalities, communities, stakeholders to engage and interact with authority. Other institutions of government, like your Chapter 9 institutions, have got a provincial presence, and it makes them easier for communities and relevant stakeholders to be in contact with them. And this too should be the case for the authority, so that they are closer to municipalities as well as community members, who are the ones that are affected by the decisions that the authority will take. And the bill maintains a long-standing proposal for a 10-year interval for municipal boundary redemarcation. This will assist to address the governance and financial sustainability challenges resulting from frequent changes, which we are in agreement with. That the bill addresses the impact of lack of presence of provincial authority for the independent municipal demarcation authority. Alternatively, that the bill provides provincial commissioners and the provincial staffing at least, that the bill ease up the appeals load by providing for provincial appeals authority in terms of decentralizing the activities of the board to ensure minimization of costs for demarcation costs, swift responses to aggrieved persons, and ensure that newly provided for dispute resolution mechanisms and the appeals process is involved and effective and timely, so that communities can get a response quickly and can engage the appeals authority timeously if there is a presence in the provinces. In particular, in the demarcation issues are always heavily contested and at times violent and destructive to public property and public order. We also believe that the bill provides for the creation of transitional grant should provide for the creation of a transitional grant funding regime for the financial impact of the municipal demarcation authority decisions and the resultant systems and change management processes that come about in terms of the transitions of municipalities, that what the bill proposes on strengthening communications consultation is sufficient and grounded in practical and meaningful interactions. The authority must be at the forefront of the public meetings and respond to questions from attendees. So the public participation processes the authority must be engaged with must be also heightened so that more people can participate in those processes and makes it easier for people to participate. Thank you very much, Chair and members.
Thank you very much. That was wonderful. Members, I am not going to open for the questions or the clarity because I think we still have to engage in processing this legislation for the public hearings, and then after we'll be going from clause to clause as we will be having the matrix in front of us, of which the SALGA also is, I think, is going to be involved as we get to be busy with the matrix of the public hearings, if that will be afforded time. So with that being said, I don't know, members, if there's any comment that you would want to make. And from me, the last question that maybe is going to be helpful before I can release the departments and SALGA for us to do the logistics that will have to be in place is to ask our national colleagues the identification of the stakeholders, because I'm looking at the SALGA with all that they are presenting to us, and to me, the initial stage had to be the partners, the stakeholder partner, as this legislation was developed for the public hearing from national. So if I can get maybe the list of who are the stakeholders that were identified for the public hearings or for consultation. Dr. Naidu, can we get the list? It will also help the members as we try to navigate for the public hearings as we send communication to some of the stakeholders that are affected by the bill itself.
Thank you, Chair. Are you talking about invitations that the committee would want to send out? And those, yeah. Look, I think it is the prerogative of the committee in terms of who those targeted stakeholders would be, but perhaps I could check, Chair, the list of entity stakeholders that the demarcation board normally engages with, and that would be, the House of Traditional Leaders, magisterial, etc., which I would share with the secretariat to the committee, Chair.
Okay, I think the question was maybe for the interest of the members to say the initiation stage of the bill itself, who were the stakeholders that were consulted, so that when we extend the pool, we can know which maybe were not consulted, and then we can be able to also communicate just to make a circle bigger for this. Yeah, so if we can get the list of those that were involved in the initial stage, not saying that we are going to exclude them now after the bill itself is in front of us, but to just make sure that we extend the pool of consultation.
Chair, if you look at the memorandum on the objects of the bill, which is attached, and section 3 of the memorandum lists in detail those stakeholders. So I'm not sure if you'd want to use that as a guide to,
So that is the only ones that were consulted. So just wanted the confirmation. Thank you very much.
Okay.
Okay, with that being said, thank you very much, colleagues, and Dr. Naidu, the team from National. I think we'll be engaging as we continue in processing this legislation, and also from our provincial department. Mr. McCann, thank you very much for joining us, and also Salga will be communicating with you. I think you are our partners that we have to do some of the logistics communicating with you. So thank you very much for availing yourself today. And I will definitely, on behalf of the WCPP, like to say have a fantastic day further, and you are appreciated on your contribution today. You can leave us to have that fantastic day. Thank you.
Thank you, Chair.
Thank you.
Thank you,
Thank you
Chair.
very much.
Thank you, Chair.
Honorable Chair.
Thank you.
Thank you, Chair.
Thank you, Chair. Bye.
Engostet. WCPP team. We do have, taking over overnight is quite a very interesting one. Okay, member Andrikas is here. Where's member Mare?
Chairperson, I think she was in an, she's under the
heard
impression she also left, yeah.
Yeah, I heard a small voice said, thank you, Chair. I said, okay. I thought that maybe there's another. Siraj, can you dial in the back member, Mari, as we continue? And Advocate Masdot, it's good to see your picture also. I need to mention that. And thank you very much. And members, we do have to determine the way forward. Now, keep in mind that as we continue, we do have very limited time. And the program, it says that negotiating mandates have to be in by the 8th March. And the final mandates as per program is 22nd March, of which it leaves the limited time. So I'm going to ask the members to apply their mind to say, what's the way forward? Already from my side, Johan, we are going to ask for extension of the dates, because this is not possible at all for us to be with a limited time for us to be done by the day that is being given to us. But the members have to chip in to say the extension has to be for how long? That's what I throw back at the members. Member Mare?
Thank you, Chair. I think this is an issue that cross-cuts many committees. I would possibly request that the extension be so that we request it be dealt with under the next administration. Failing that, public participation in April. However, I don't see that being feasible because I imagine Parliament will close towards the end of March.
Yeah. I agree. Member van der Westhuizen? Okay. Member Glass?
Thank you. I support the idea that was being said that let us close for the next term, because now the time is limited. It's not a good time for us to deal with this thing as it's supposed to be. So I will agree with the first proposal.
Okay. Advocate Masdor, we need your advice. This has been referred to us, and extension or suggestion as member Mary, it can be what we put in, but we are just one province in amongst the 9 provinces. I don't know what is the feeling of the other provinces. What are the other options that maybe we can have within our parameters to deal with this? keeping in mind the challenge of the time frames, because we still have to do the budgets, we still the main appropriation bills and other legislations that are already out, like your Bela bill that are out that they are doing in the public hearing. Legally.
Chairperson, you did refer to me, and that's not a problem. I would, however, defer the question to my colleague Kutsi, since it is very much procedural in nature. If it's okay with you, that I defer to my colleague Kutsi and I could back up or just complement whatever he says.
Okay.
Thank you, Chair.
Thank you very much. I wanted to ask what are the options legally, but procedurally, I was going to use what you give us, the option 1, 2, 3, 4 to give to the procedure, our procedure to say that what will be doable, but we can do vice versa. I'm game. Johan?
Chairperson, yes, I had a discussion with my counterpart at the NCOP, and there are other provinces that's under the same pressure that has sort of expressed also the satisfaction at the short time frame. And if you look at the dates when this bill was initially introduced and the process that was followed, to give provinces only a 3 months or a term to deal with it, I think it's not fair. So procedurally, I would suggest that we put Member Murray's proposal through to the NCOP and let them then decide whether they will accommodate us, or if not, then we'll have to deal with it.
Okay. I'm in support, member class is in support, and our legal advisor is?
Chairperson, I agree with my colleague Kutsi. I would, however, say that it is still incumbent on this committee to exhaust whatever opportunity it can to have public hearings, 1, and 2, to ensure that the available time is used optimally by this committee, and not to preemptively just ask for an extension as if when we don't get an extension, we've now tried our best to get an extension and we didn't, and therefore procedurally this bill is not to be supported. We must be very careful as lawmakers, that we invest our energy, our time, our effort as an institution to use the available time within our confines. Take note, we are one of 9. We're not the only province in the country. We're one of 9. To use the available time and energy and resources to have as many public hearings as possible. I would have thought that the committee would explore the number of meetings it can have with the public in view of the other bills where the committee may, or the committee members may be involved, and that should it not find that it can cover the whole province, then, and in that event, it engages the NCOP for an extension, but not to preemptively, for the sake of it, ask for an extension so that we can build now already an argument later that we didn't get the extension that we deserve or that we wanted. Let's be prudent as lawmakers, see how many meetings we can extract in the available time, and then when we get closer to maybe the cutoff, we haven't heard of any election date yet, when we get closer to that time, we can ask for an extension. Then we can say, we've tried our utmost to have 4, we only could make 3, can we get an extension for a week or for 10 days? Let's be prudent about this, mature about this, and open-minded as lawmakers, because we are part of 9 other entities who try to squeeze this constitutional mandate within the available time. Thank you, Chair.
Thank you very much. Advocate Masdam, thank you very much. That's why I wanted you to talk to us before. My suggestion is this, Johan. If we can, the members can agree that we start by get the research and the public outreach to identify the stakeholders, all stakeholders that are they can be able to do the submissions. And then we do the other options of the submission, the online submissions, as we plan and get the dates of the adverts on the newspapers or. And after that, as we plan the days and looking at the parliamentary program that is already, I think, Programming Authority today, I looked at it, it's just, I don't know how are we going to go about, but like Advocate Masdorp say that maybe we can use, if possible, the option of where there's already public hearings. So we use those places also to can go there and see what are the other avenues that we can use, but not give the sort of, I nearly use the word that I use when I'm at home and I'm on YouTube account, but not sort of shift everything to say we are going to wait for the response from the NCOP. What do you think, Johan?
Chairperson, no, that's correct. I think members Murray's proposal was sort of down that line.
Yeah.
If I can just then recap, member Ms. of Chairperson, is that we sent the letter to the NCOP.
Yeah.
Requesting that it maybe stand over to the new administration
Mm-hmm.
or alternatively to extend the process. And in the meantime, we write to the various stakeholders, we go onto social media, we request for written input and comments and an indication that if there are anybody that wish to make oral submissions to indicate to us by a cut-off date, because we remember we have got the dates from the NCOP for the negotiating mandate, which is the 8th of March. And then, so we start that process as well. So these two will run parallel. And then once we get feedback, we can see where we can then go and have the public hearings, keeping in mind that there is quite a few other NCOP bills that's running with public hearings as well. But we will run the both processes in parallel and get the process running.
Okay, so when we open for the adverts, it will take how long for the adverts to be out?
Member Maseko, I would maybe at this point stay away from adverts and because if we advertise, we'll have to advertise for at least 3 weeks to provide public with proper time frame to submit their comments. It is the 13th of February today. The cutoff date for adverts would be on the 22nd of February. So we'll try and get it into the newspapers around about the 23rd, 24th of February, which is in a week from now. And then if you give them 3 weeks or even 2 weeks, the closing date would be on the 8th of March. If it's on 2 weeks, if 3 weeks is the 15th of March. So I would, and then remember, Maseko, if we don't get to public hearings, we would have had spent that amount of money on adverts that we are not going to conduct public hearings on. So I would maybe say let's do the social media and let's just write to the stakeholders. This is a very specific related to the municipalities and or stakeholders within that sphere. And then we'll see what the reaction is from the written request for written comments and indication whether they want to make oral submissions. And then we take it from there. We can then advertise and say, look, we will have public hearings at these places and go for it.
Okay, I think I'm going to leave this as an interim chair. I'm going to leave it with, in principle, the members, you hear the members what we are saying, run that parallel process, but we mustn't deviate too much from the legislative requirement of what needs to do for the public hearing. That thing must, if we have to process this bill, there is no time, but we still have to process it. It mustn't be someone goes to court to nail us because we try to cut short the the process. So we need to be inclusive as much as we can for those who are affected by this bill. So you hear what we are saying, that run that parallel process. You can do the social media, and how are you going to check if it has reached everybody else that have to comment? It will be, we will come back to the meeting to check that. If you can have an urgent meeting, if maybe there is a challenge, that will be important. But let's try to process the legislation and the parallel process of talking to NCOP and using our parliamentary program to support the extension of time, because we don't have, with the parliamentary program, it's a little bit difficult with the limited numbers of members, that we cannot have others in here with them responsibilities and also going out for the public hearings. So let's see what we can do to make sure that we do what is expected from us. Members? Is that all? Are you in agreement?
Supported, Chair.
Okay, I'm going to take that you agree with me. With that being said, Advocate Masdorp, Siraj, Nomfundo, and Johan Kutzi, and Matlodi Maseko, thank you very much, honorable members. I am going to leave that with you, our favorite procedural officer of the local government, to communicate with us. We've got the WhatsApp group where we can communicate if there is a challenge or clarity that you'll need from the members, and we'll continue as such. With that being said, members, the meeting is adjourned.
Thank you, Chair.
Thank you very much, Chair. Thank you, members.
Thank you.
Mostly, Chair, mostly, Scott.
Okay, sure. Bye.